Alan Frazer and his wife Flora Frazer were the registered proprietors of a farm in New Zealand. In other words, they were officially recorded as the legal owners of the property. Without her husband's knowledge, Mrs. Frazer borrowed £3,000 from a lender, Radomski. To secure the loan, she mortgaged the farm. However, there was a critical problem. Mrs. Frazer had forged her husband's signature on the mortgage documents. She then sent the forged mortgage, along with the certificate of title, to Radomski, who in return advanced the £3,000. When Mrs. Frazer failed to repay the loan, Radomski enforced the mortgage. He exercised his power of sale and sold the property to a third party, Walker, for £5,000. The transfer to Walker was registered, giving him fee simple ownership, the highest form of proprietary interest, granting full possessory title. If you want a deeper understanding of fee simple, check out my video on numerous clauses. Walker then brought proceedings against Mr. and Mrs. Frazer, seeking possession of the farm based on his status as the registered proprietor. In response, the Frazers filed a defence and counterclaim. They argued that because Mr. Frazer's signature had been forged, the mortgage and everything that followed from it was invalid. They sought to have both the mortgage and Walker's registered title set aside. The outcome of this case ultimately turned on the doctrine of indefeasibility of title. Under this doctrine, a registered proprietor generally holds title that cannot be challenged by earlier defects or adverse claims. In simple terms, once your title is registered, it is protected, especially if you hold a valid certificate of title. Here, the Frazers' claim failed. The court refused to cancel either the mortgage or Walker's title. So does this mean that indefeasibility of title is completely bulletproof? Not quite. It can still be challenged in certain situations, particularly through personal claims in law or equity. However, in this case, both Radomski and Walker had acted in good faith. They had no knowledge of the forgery or any wrongdoing by Mrs. Frazer. Section 56 of the New Zealand Land Transfer Act reinforces this position. It prevents courts from cancelling a registered interest once it has been transferred to a bona fide purchaser for value, that is, someone who acquires the property in good faith. This case shows that the threshold for defeating indefeasibility of title is extremely high. Even forgery on its own is not enough. Looking at this from Alan Frazer's perspective, the result seems harsh. He lost his farm due to a mortgage he never agreed to, based on a signature that was forged. But if registered interests could be defeated simply because of forgery, even where the mortgagee acted in good faith, it would undermine the entire tolling system. That said, modern law has evolved to provide greater protection. For example, in New South Wales, Section 56C of the Real Property Act imposes a duty on mortgagees to verify the identity of the mortgagor before registering a mortgage. These due diligence requirements help ensure that the true owner has actually consented to the transaction.